hope not.
Oh, it says interpreter on the, it's got it listed on the sheet.
Oh, I wonder if they got an invite. Let me make sure. Mr. Lawrence, does your client need an interpreter for today's hearing?
Email received.
You're muted. You're muted, Jonathan. I don't see it. Well, I don't see that. I sure didn't invite one. Jonathan, you're muted. Can you hear us okay?
Judge, can you unmute him as the host?
Ask to, well, I can ask to unmute, it says.
Judge, I know that I had to have the attorney help me with the LSIR process because of language barrier.
Well, we'll see if we can get it done. I just, there you go. It says you're unmuted. Still can't hear me. Huh.
Still can't hear you. You're not muted, but I can't hear you.
I typed to Mr. Lawrence. Seems like he's having technical issues. I didn't get an interpreter, and asking if his client needs one. If he does, we'll need to reschedule.
I thought he was nodding like he could hear us. We just couldn't hear him.
You
can hear
That
us?
seems to be the case. We can't hear you. Does your client need an interpreter? No.
No.
Okay. Yes. Call. Can you call in the number and hopefully we can get audio through that?
I've done before and get audio. Just do the Zoom itself on the phone. I've done that before.
Judge, is he in on the phone?
There it is. Yeah, I was watching and
Can anybody hear me?
yes.
Yes.
Okay, I'm gonna put you on speaker. I can see everybody. I don't know what the deal is with why I cannot speak through my computer, but I've got my phone here. Can everybody hear me?
Yes.
Yes.
Okay, and we can hear over here. And Mr. Bilbao does not need an interpreter. He understands English very well and knows what's going on today.
Fantastic.
And I'm sorry about the mask. I got so frustrated I couldn't talk with it on.
I understand. All right. Let's be on the record in case number 2019-CR1061, captioned State of Kansas versus Victor Bilbao. Would the parties announce their appearances, please?
May it please the court, the state of Kansas appears by Assistant District Attorney Claire Thibodeau.
Good afternoon. I'm Jonathan Lawrence, and seated to my left, and I'm not sure how it's appearing on your screen, but on the left is Mr. Bilbao.
All right. We are here set down today for a sentencing, a brief history of the court proceedings are in order. Allow me 1 second here. It appears that back on July 10th, the parties appeared by Zoom. The defendant changed his plea from one of not guilty to guilty. The court inquired and accepted, ordered a pre-sentence investigation, and set sentencing for today. I've received a copy of that pre-sentence investigation. The critical findings are as follows. The sole count of conviction is one of possession of cocaine, which is a severity level 5 non-person drug felony. The defendant's criminal history score was found to be that of I, as in Isaac. That would leave him with a presumed sentence of probation with a presumed underlying term of 10, 11, or 12 months. If he has to do that time, he'll be eligible for 20% good time credit and subject to 12 months of post-release supervision supervision release. If he's granted probation today, it would be for a period of 12 months to court services. The LSI score showed that he was low to low moderate risk. I would ask you, Ms. Thibodeau, did you have an opportunity to review the PSI? Do you have any additions, corrections, or challenges to those findings?
Judge, I have received the PSI and have reviewed it. I do not have any additions or corrections.
Mr. Lawrence, same question.
Judge, we've received it and we've gone over it and we have no objections.
All right, Mr. Bilbao, this one's kind of easy. I usually ask the defendant if he went over his criminal history score with his lawyer. I see that you scored no criminal history that is scorable, so I assume that you agree with that finding. Is that correct?
Yes, sir.
All right. I will adopt the findings of the pre-sentence investigation for today's hearing, and I would hear your comments upon sentencing, Ms. Thibodeau.
Judge, I would just ask you to follow the plea agreement. In this case, that was for him to plead guilty to the possession of cocaine, and that the parties would jointly recommend 3 months off the mitigated box in probation. So I would ask for you to sentence the defendant to a 7-month underlying, and then ask the defendant to get a drug and alcohol evaluation, a domestic violence evaluation, and follow all recommendations. I would also request no violent contact with the victim, who I believe is his wife.
All right. Mr. Lawrence, your comments, please.
Judge, I'd ask you to follow the same recommendations. The only question I have, just because I've not had a plea in this division, prior to the guilty plea, Mr. Bilbao did get a complete drug and alcohol evaluation, and I've tendered that to Ms. Kebido and to Michelle Herron. And then I believe it was subsequent to the July 10th plea, he also got a domestic violence evaluation, and I've also provided that. Is he required as part of the sentence to do these again, or will those suffice?
They will suffice. All I will order is that he follow the recommendations thereof.
Okay.
All right. Ms. Thibodeau, any objection to that?
No, Your Honor. I would also, I'm not sure if you, Judge, require a written motion for a departure or if Mr. Lawrence just needs to say some factors for his substantial and compelling factors for the departure.
I normally do, and I just noticed that there wasn't one on file. I'm going to go ahead and waive that today. Mr. Lawrence, if you had to make an argument as to factors supporting a downward durational departure, I assume that would be your client's acceptance of responsibility, his first time with finding himself on this side of the law, and that a lesser underlying sentence would serve defendant reformation better than a prison sentence. Is that correct?
Yes, Judge.
All right. Just and no big deal. I should have said something to you at the plea, but normally it's a local rule here that we need a written motion for departure anytime that the agreement calls for it or that a party is seeking it. All right. Okay. Mr. Bilbao, now is your opportunity to tell me anything you want me to know in mitigation of your sentence today.
None.
All right.
Judge, if I may,
Yes.
he might perhaps be a little confused by the question. I had indicated to him that I would cover that if that's okay. He's kind of nervous. This is his first his first interaction with the criminal justice system.
Sure.
If I could just say a few comments on his behalf.
Yeah. Mr. Bilbao, one of the things is the court is required by law to offer you an opportunity to speak on your own behalf. Oftentimes, defendants don't want to do that. They're nervous. They've talked to their lawyer. They're satisfied with what their lawyer has to say. And if that's the case, that's absolutely fine. I'll just take it that you don't wish to make any further statements. Is that correct?
Yes, sir.
Okay, fantastic. All right, Mr. Lawrence, do you know any legal reason why I should not now proceed to sentencing?
No, Your Honor.
I am going to follow the plea agreement, and I am going to grant the motion for downward durational departure, making the findings of substantial and compelling reasons as follows. That Mr. Bilbao accepted responsibility and has taken steps to address the underlying reasons for these charges in a forthright manner. I believe that granting him the downward durational departure would serve defendant reformation better than, and public safety better than imposing any kind of a prison sentence. Therefore, the defendant will be sentenced to a period of 7 months in the Department of Corrections. If he has to do that time, he would be eligible for up to 20% good time credit and subject to post-release supervision duration of 12 months. His application for probation to court services is considered and it is granted for a period of 12 months. The specific terms of that probation will be that Mr. Bilbao is required to follow the recommendations in his alcohol and drug assessment as well as his domestic violence assessment. All right. Since Mr. Lawrence is retained, I'm assuming and that Mr. Bilbao was able to make his own bond here, I'm going to assume that he has the ability to pay the court costs, the supervision fee in this. There isn't a bids fee or an appointed attorney fee as Mr. Lawrence is retained. There is a requirement of a DNA database fee being paid, since this is Mr. Bilbao's first felony conviction here in Kansas. So I'm going to assess that. There will be no fine. I take it, Ms. Kebido, the drugs were not tested. We don't need to do a laboratory fee.
I believe so, Your Honor.
All right. Mr. Lawrence, would your client want me to have those costs and fees taken out of his bond before it's returned so that he doesn't have to worry about paying that in the future?
Judge, do you have a subtotal?
I'm going to give you a ballpark here from my normal cost sheet. The court costs are about $190. Supervision fee, I think, is $150. Is that right, Michelle? Close to? Yeah. So there you're at $350. I think the DNA database fee is it 400?
Is it 300 or 400?
You're muted, Michelle.
I'm sorry, Judge.
That's all right.
I thought it was 400.
I think so.
It's either 2 or 4.
The problem with the cost sheet is it doesn't say exactly what it is. So I'm going to go, I'm in trying to give him a ballpark figure. That's probably about $400. You're talking about $750 ballpark.
They can take that out of your bond. Yeah. Judge, we would like to have that taken out of his bond.
Okay, I will so order. That'll take care of all of that for as far as payment plans go. All right, Mr. Bilbao, you have 14 days from today to appeal anything you don't like about your sentence. As a convicted felon, it is prohibited for you to own or possess a firearm and certain kind of deadly cutting instruments like dirks, daggers, switchblades, basically knives that could be considered deadly weapons. I won't go through the whole list. Just suffice it to say, before you decide to own or possess any kind of weapons like that, make sure you talk to a good lawyer like Mr. Lawrence to make sure there wouldn't be reason to revoke a probation or add new charges, okay?
Okay, sir.
All right. Now, once you finish probation here after a period of time, you may seek expungement of these charges. I would suggest that you probably want to do that. Mr. Lawrence can probably explain more about that to you, but I think it would be a good idea for you to figure out what those timeframes are and leave yourself a reminder to seek that expungement in the future so this felony can be taken off your record. Okay? All right.
Judge,
Folks, yeah, yes, Mr. Lawrence.
I'm sorry. Just before you close, I just wanted to interject. We have 2 questions
Okay.
concerning probation once this is wrapped up. But before everybody gets off the phone, and since we've got Ms. Heron here.
Right. Okay, so probation, what I'm going to want you and your client to do as soon as we hang up here, you'll call the front desk for probation, 573-2846. Let them know your client's name and case number, that he was just sentenced to probation with court services, and they will instruct him what to do from there.
Okay.
Other questions?
Yes, Judge. Two. And maybe we'll find this out later, but I just want to ask while I've got people on the line. On the worksheet, the box for community service was checked, but with no number in there. And I wanted to talk about that because Mr. Bilbao is a subcontractor for a flooring contractor, works about 50, 60 hours a week, and he's got 2 crews going in 2 different residences at all times. And there'll be kind of an impact to him and an impact upon his employer. And if there was some substitute, if community service was going to be ordered, it doesn't show that it's ordered, but it's ambiguous because the box was checked with no number given. So I promised him I would get clarification on that today.
I will waive, given his employment, as long as he remains gainfully employed, he will not be ordered to serve any community service.
Thank you. And then the other question was, does this supervision preclude him from traveling out of state, for example, to family gatherings or what have you? What is the court's position on that or probation officer's position on that?
The
Does he
probation
notify anybody? No.
the probation officer's position, and they'll have a contract for him to sign, will be that he is not to leave the Kansas City area without prior permission from his officer. Now, they're pretty, as long as people are compliant with their probation, they're pretty flexible with that. Leaving the country can sometimes be a problem because, there's no, the long arm of the law doesn't cross the border. So,
Right.
Sometimes that's more of a sticky situation, but as long as he's in compliance with his probation, I have found in my practice, it's their call, but most probation officers are pretty flexible with that.
Thank you, Your Honor. That's all we had, but I just wanted to make sure that I raise it now and then we get clarification today rather than run into a problem later.
Absolutely. All right. Ms.
Judge.
Kevadel?
I have 1 day of jail credit for the defendant. And did you order no violent contact with, I believe her name is Yeni Bilbao? I don't know if I missed that part or not.
I
did.
did. I forgot to do that. If Mr. Lawrence agrees that his client served 1 day, that's the jail time credit. And Mr. Bilbao, you will be ordered to have no violent contact with the victim in this case. Now, obviously, I think you guys are in a relationship. You're allowed to have contact, but what you need to know is if something goes sideways, your fault, her fault, or anything, if the police get called out there, there's an opportunity that your probation could be revoked based on anything that happens. So, look, I don't want to stand between you and your relationships. I just want you to make sure that the burden's going to kind of be on you to make sure that it's domestically tranquil, at least to the point where law enforcement doesn't get involved, because you would be the one that would end up paying the price for that, okay?
And Judge, I think there are a couple of counts to be dismissed too, but I don't mean that presumptuously. I think there are 2 other unresolved counts.
I dismissed those at the plea
Oh,
hearing. Yes.
Okay.
Yeah. Right. Okay. Ms. Kevadel, anything else for the record?
No, Your Honor.
Mr. Lawrence?
I just want to thank everybody for working with us and resolving this case favorably.
All righty. Thank you. Mr. Bilbao, good luck to you. Give probation a call. They'll get you going right away, okay?
All right. Thank you, sir.
We are adjourned. Have a good weekend.